Pregnant Workers Fairness Act, also known as the PWFA, is a newer federal law that went into effect on June 27th, 2023. PWFA applies to employers and businesses, both public and private, that employ 15 or more employees. If an employer has 15 or more employees, they are considered under the PWFA to be a covered employer. If you are an employer with 15 or more employees, you have likely already familiarized yourself with the Americans with Disabilities Act, or the ADA. The Pregnant Workers Fairness Act is modeled after the ADA in a way that expands protections for pregnant employees and job applicants. If you are wondering why pregnancy and related medical conditions were not just added under the umbrella of the ADA, it is because, in part, pregnancy is not viewed as a disability, but rather a temporary medical condition that will resolve itself at some point in the future. The PWFA protects employees and job applicants of covered employers who have known limitations related to a pregnancy, childbirth, or related medical conditions. Covered employers should be aware that they are now required to make reasonable accommodations for employees who make it known that they have limitations related to a pregnancy, childbirth, or related medical conditions. What does and does not qualify as a reasonable accommodation under the PWFA will depend on a number of factors, including but not limited to the employee's medical condition and their restrictions, the employee's job duties and responsibilities, the nature of the employer's business, and whether or not the requested accommodation would impose an undue hardship on the employer and the business. When a covered employer receives a request for accommodation from an employee with known limitations, it is imperative that the employer engage in an interactive process with that employee to determine how and if the requested accommodation can be provided, and whether or not the accommodation would impose an undue hardship on the employer. The Pregnant Workers Fairness Act actually encourages the initiation of the interactive process by prohibiting employers from requiring an employee to accept an accommodation without a discussion about that proposed accommodation. That discussion needs to happen between the employee and the employer. In order to engage in an effective interactive process, employers should request documentation of an employee's medical conditions and limitations, and they should create a written record of conversations with that employee regarding any limitation, medical condition, as well as any proposed accommodations. It is important for employers to take measures aimed to protect employees who have requested reasonable accommodations from retaliation, threats, or similar adverse action. This matters to employers because it is much easier and cost-effective for employers to engage in that interactive process with an employee or job applicant on the front end rather than dealing with the headache and expense of defending a lawsuit that alleges a violation of the PWFA that may be brought by a current or former employee. The Pregnant Workers Fairness Act allows for a successful plaintiff to recover lost wages, compensatory damages, for example, mental anguish, emotional distress, and possibly punitive damages if deemed warranted. Ensuring compliance with the requirements set out in the PWFA could save an employer thousands of dollars in attorney's fees, in addition to any lost wages, compensatory damages, and punitive damages that may be awarded. In addition, an employer could be on the hook for the opposing party's attorney's fees if they are found to have violated the Pregnant Workers Fairness Act. The bottom line is that employers want to make sure that they are in compliance with the PWFA in the event that they are faced with an employee or applicant who requests a reasonable accommodation for a pregnancy-related medical condition.